If there are no corrections to page 1, we turn to page 2, paragraph 5. Paragraph 6. Paragraph 7. There is no correction to page 2. We go to page 3, continuing paragraph 7. There is no correction to page 3. We move to page 4. There is no correction to page 4. We go to page 5. Second paragraph on page 5. If there is no correction to page 5, we go to page 6. There is no correction to page 6. We move to page 7. There is no correction to page 7. Will someone move for the confirmation of the minutes?
I so move, Madam Chair.
Senator Sinclair, seconded.
Seconded, Madam Chair.
Thank you. Senator Scott Motley. We move to item 6, matters arising. Any matter arising from the minutes?
Madam Chair, I note that letter has been circulated from the Attorney General's Department, Mr. Foreman. Would we be dealing with that letter now?
Yes. Yes, Member Scott Motley.
Yeah, and it's a matter arising. I think it would, if there is nothing else pressing, perhaps we could move to that.
Yes. Mr. Foreman? Mr. Foreman, may I invite you to go through the document you have presented in response to my request from last meeting. Let me first thank you for reducing into writing the comments. Please take us through.
Yes. So the letter captures what I said at the last meeting, the contents of which I think are accurately reflected in the minutes. I start off by noting the provisions related to the detention periods for the pre-charged defendant and the defendant who is charged with an offense for which bail may be granted only by a judge. And I observed that scenarios will be created where someone is reasonably suspected of having committed the same offense, but the time period within which they have to wait before appearing before a judicial officer will be longer if they are in the pre-charge category than if they are in the post-charge category. I note that there are some undesirable potential implications for that type of structure. I first note that, in my view, Section 14, as I've said, places a premium on the detained person appearing before a judicial officer as soon as possible, so that the judicial supervision of the detention is viewed as the ideal scenario. And the cases I've looked on in various ways support that sort of approach. I also note that the Section 14 regime is broadly subject to a requirement that the procedures which are introduced by law to permit detention in the various circumstances allowed by the Constitution should be fair, and that there may be an argument that someone who is detained in a pre-charge regime could make, to the effect that the law is allowing me to be detained for a much longer period before I have the ability to convince a judicial officer that I should either be released or that I should be released on specific types of conditions. And then related to that, which was not a point I had raised at the last meeting, but having had to discipline my thoughts to writing, I acknowledge that there's a potential equality concern that could be raised in the context of the right under Section 13(3)(g) of the Constitution to equality before the law. I think there's a reasonable argument to be made that the pre-charge and post-charge person in the context in which we're discussing it are in comparable, analogous, or broadly similar circumstances, so as to invoke the right to equality before the law, and therefore demand justification for the difference in treatment in those circumstances where that difference might arise. And I acknowledge the rationale that was advanced, which is that the person who has been charged should be expeditiously brought to trial, and that having the person appear within the 48-hour period would advance that objective. But I know that particular concern relates more so to the right to a trial within a reasonable time, not as much to the other right, which is the right to be brought promptly before a judicial officer. So that the concern that I have in relation to those circumstances where persons reasonably suspected of having committed the same types of offenses might be treated differently and in a manner which does not achieve the constitutional ideal of a prompt appearance before a judicial officer. So that in summary is the content of my letter, which I have said reflects the views I expressed at the last meeting.
Thank you, Mr. Foreman. Any question or comments from any member?
Well, Madam Chair, I'm hoping that some of the other members will express their views. As you will recall that I was actually present when Mr. Foreman made his presentation, yes, and I agreed with him.
Yes.
I thought his observation was very timely, and I was deeply appreciative of his comments. But the other members had not commented, so I'm hoping at this time that they find they take advantage of the opportunity to do so.
Thank you,
well,
Member Scott Martling.
Madam Chairman, since I wasn't at the last meeting, what was the response of the committee, and in particular the government, to these very valid concerns? Were there proposed amendments to mitigate against these risks or concerns that were pointed out from the AG's chambers?
The concern expressed by Mr. Foreman. Mr. Foreman, remind me, you do have a background in criminal law also, and experience at the criminal bar?
No experience at the criminal bar just yet.
I see. All right.
I don't think it's necessary though.
Sorry, Member Paulwell?
No, I'm so sorry, Chairman. I've been facetious.
you have experience at the criminal bar, Member Paulwell?
Not at all, not at all.
Right. No, I just ask because some things are a little clearer when you see them in action. I believe Member Scott Motley does have experience at the criminal bar. Am I correct?
That is so.
Right.
That is so, Chair. But sometimes I find that the experience differs vastly from the legislation. And that is why I'm always grateful when persons can look at it extremely objectively. Yes. Some of the experiences we have had practicing would, if they were made and known generally public, there would be great concern about the way in which it actually works out in practice.
Right. So the issue is a differentiated time period for two categories of defendant. Both are detained and therefore deprived of their liberty on reasonable suspicion that they have committed an offense. One category is not yet charged and the other is charged. And we're looking at a differentiated time frame for bringing the defendants before the court. Mr. Foreman is of the view that the time frame should be the same. And I note he has indicated constitutional entitlement to judicial supervision of their detention. And he groans that he says that the Constitution places a premium on the detained person appearing before a judicial officer. And he references Section 14, but Section 14, Mr. Foreman, does not limit the competent legal authority to the judicial officer. Is that correct? The Constitution provides for the person to be brought before the competent legal authority. And constitutionally, such an authority is not limited to a judicial officer.
That's correct.
Would you say? That's
but the
correct?
Constitution goes on. Right.
Right.
But the Constitution goes on to say
let's take it in stages, Mr. Foreman. Let's take it in stages. All right. So, benefiting from the guidance you have provided through the research, we know that it is not whether the charge is preferred or not that would meet the constitutional threshold for deprivation of liberty as an exception to the guarantee under our Constitution. It's whether, in the particular circumstances, there is reasonable suspicion that the person has committed an offense. And we know that you do not move from reasonable suspicion to trial within a reasonable time immediately, that there are various steps and stages between that initial deprivation of liberty and getting to trial within reasonable time. So if a defendant who is suspected of having committed an offense but is not charged, and a defendant who is suspected of committing an offense is charged, would you say that the two defendants are at the same stages of proceedings? Mr. Foreman?
Right. My response to that is to say that regardless of
let's
stage
just
of
take
the
it step by step.
proceedings.
I'm saying a defendant, we have two defendants in custody. both of whom are reasonably suspected of having committed offenses. One is charged and the other is not charged. Would you regard both of them as being at the same stage of the proceeding, criminal proceedings?
No.
Very well. So, competent legal authority under the Constitution is not limited to a judicial officer. And two defendants, both of whom are reasonably suspected of having committed offenses and who are deprived of their liberty, one is charged and the other is charged. They are not at the same stage of the proceedings. No, the one who is charged, would you say that he is further down the road in the proceedings? In other words, once you lay the charge, you would have had the basis for trying the person.
Yes.
Right? And then the law, the Constitution says that trial is to take place within a reasonable time. And of course, you can't try someone if you don't charge them.
Mm-hmm.
Right. And the person who, the detainee, a detainee is to be brought as soon as is reasonably practicable before an officer authorized by law or a court, even in the provision which speaks specifically to trial within a reasonable time. Does the officer authorized by law limited to the court or a judicial officer?
No.
Very well. So that what would be the prejudice to the defendant who is not yet charged and therefore cannot yet proceed to trial to be brought before an officer authorized by law who is not the court when the Constitution specifically provides for it?
The prejudice that I am identifying arises in those situations where the pre-charge defendant is not released on conditions or unconditionally within that 48-hour period. And the statute says that there's another 48-hour period that must elapse before that person has to be brought before a judicial officer.
So within the first 48 hours, is he being in the scheme? Is his status being assessed by an officer who is authorized by law, a competent authority, for a determination to be made whether he is to be released or he is then to be taken before the court? I mean, is a determination being made within the scheme?
Yes.
Right.
But as I indicate,
yes,
it's you can't stop there in reading the provision. The provision has two aspects to it. So the one part permits a judicial officer or an officer authorized by law to make that assessment. And then it goes on to say that if the person is not released, that the person has to be brought promptly before the court, so that the court can make a determination.
Right. So if the person is not released and the person is then to be taken before the judicial officer, isn't that an opportunity for what you have described as this judicial supervision to happen? Because not all defendants are going to remain in custody.
Yes, but it's happening at a later stage in the proceedings than someone
But if you have to provide an
is
opportunity,
similarly
Mr. Foreman,
circumstanced.
Mr. Foreman, as a matter of policy, if the policy is to permit defendants to be assessed and those who can be released, the policy is that bail is to be granted not only in court, but also out of court. And if that is the policy, do you not need to provide the time for the administrative steps to be taken?
That policy has to cohere with the policy of the Constitution.
But
And
the Constitution does not
policy
forbid. Hold on, because this is what
Madam Chairman, a point of order, Madam Chairman.
we're interrogating the matter, Mr. Paulwell. What is the point of order?
Well, it sounds more like cross-examination.
No, ma'am, we're trying to get to it because there is a difference between what is unlawful or unconstitutional and what you may desire. That is what I am interrogating.
No, but
No,
Madam
but
Chairman,
I join with
of your constant interrupting of Mr. Foreman, I don't think is that of an impartial presiding officer. You are interrogating him from the perspective of trying to prove your policy position. We on the committee want to hear his independent judgment on the issue, not to see him pilloried by you trying
Mr.
to
Bunting,
force
that's a
your
strong
opinion
word. That's a
upon
strong
him.
word. That's a strong word. Well,
But Minister, I was thinking the same thing when I was listening to your cross-examination, which is how it came across.
interrogation.
Mr. Foreman.
Interrogation is,
No,
is a
it
better
sounded
word.
like a cross-examination with intent to prove him wrong. And I did not understand that that was the purpose of a participation in a joint select committee.
No,
Because if you have administrative views based on your policy and the Attorney General's department, and you would understand the significance of that department, having been Attorney General yourself, seeks to intervene, to raise a concern, I think we should respectfully consider it amongst ourselves and not set out to prove that he has not looked at the Constitution and interpreted it accurately. That is a matter for the court. Respectfully, as from last week, I tried to express my views,
Senator,
which is that Mr. Foreman was in fact trying to ensure that this bill, if it became an act, could pass judicial scrutiny. The concern, as I understood it from that occasion, was that the person who is not charged, the person who is on bail, but is not charged with an offense, was placed in a lesser position than somebody around whom the police had sufficient evidence to prefer a charge. And let's start at the beginning.
hold on, Member
Under
Scott
this
Motley.
bail act,
Just hold a minute.
Just one last comment.
Yes.
Remember that this is not new that people can be granted bail by an officer.
Right.
A person can get what we say station bail.
So
it's not a new concept that an officer can grant bail.
So the issue that we are interrogating, or certainly that I'm interrogating, is the desire or a preference for the time frame to be the same for a defendant who is not charged and a defendant who is charged to be brought before the court. That is what I'm seeking to interrogate. Now, if it is accepted that the two defendants are at different stages in the proceedings, then the argument that an equal time frame, unless there is an equal time frame, there is no coherence, is really what I'm seeking to get to. And that is why I've been asking the questions. So if it is that the two defendants are at different stages of the proceedings, and different things apply at a different stage, then it stands to reason that a differentiated treatment is not necessarily anomalous, even if you may desire to have them treated in the same way. That is really what I am interrogating with the questions. Because I note, not from Mr. Foreman, but I note the speed with which an allegation of unconstitutionality is made. And an allegation of unconstitutionality cannot be taken lightly. But not every allegation is going to be, is a valid allegation or a proper allegation. And I find that it has become fashionable for a position that is different from one being proposed to be labeled unconstitutional. That is what Member Scott Motley, I'm really trying to understand. So it's not a matter of my wanting to rip Mr. Foreman at all. Not at all. Not at all.
But Minister, you know, my understanding of what the process that we are going through.
Yes.
And my understanding of Mr. Foreman's advice is not that he simply wants to say that it is unconstitutional in his view, but that he wants to have an act presented which can stand the test of the courts. So it's not because it's fashionable. I'm not aware of how it has become fashionable, but because we are embarked on a certain journey here.
But we're trying
Madam,
to solve
respectfully, listening to you, it almost appears as if you're a judge in your own cause, defending the policy of the government. That is how it appears.
Not at all. When you develop policy, though, you have to be able to defend the policy. No, not a judge in the own cause at all.
But might I suggest, Madam?
Yes.
Madam Minister?
Yes.
Yes. I do believe it is unseemly for the Minister and the AG's department on this public network to be at odds.
No, man. No. Don't frame it like that at all. Do not frame it like that, Member Paul Will. It is quite okay for us to thrash out matters, hear the views. You know, in the practice of law, that is what happens. You get to the bottom of submissions.
But he's your lawyer.
Sorry?
But he's your lawyer.
Yes.
He's your lawyer.
But even when you have your own lawyer, you want to understand where the matter is coming from. Remember, we're not legislating for ourselves.
Madam Chair, I just...
No, I don't share the view. I don't share the view. Yes, Senator Fitzhenley.
I mean, the rush to defend, for want of a better word, Mr. Foreman, I'm a bit puzzled at that, because I'm of the view if an officer of the Attorney General's chamber has submitted an opinion, that individual must be prepared to explain and articulate on the various points. And I was quite enjoy hearing the discussion, the raising of the various points. And I think Mr. Foreman was holding his own.
Yes.
And I think it's an appropriate forum for the issues to be discussed, that we may get a better understanding of the appropriate course of action proceed. I'm somewhat at a loss. The rush to defend Mr. Foreman was basically articulating, where he came from, and the chairman of the committee was putting another view, or seeking to properly understand that which has been submitted to the committee by the Attorney General's chamber. So, I think the rush to defend Mr. Foreman is perhaps premature.
Chairman, I wish I had taken a decision that I would restrain myself from making any further comments, as I had made my position clear from the last meeting. But I find it very unfortunate that a new member to the committee would see the crosstalk and the discussion as a rush to defend Mr. Foreman. I think the choice of his word defend is unfortunate, and perhaps it is because he does not have sufficient experience as to how joint select committees are conducted. It is the time when people forget or try to put aside their partisan inclination to arrive at legislation which is fair, just, and which can stand the scrutiny of the courts. And I would suggest that he look back at some of the sessions and view other joint select committees before saying one is rushing to defend, because it gives the impression that a partisan approach is being taken where the Attorney General is your attorney to guide and advise you.
Senator Scott Motley.
With the greatest of respect, Member Scott Motley, I heard words such as the gentleman.
Yes, go ahead,
and I think
Senator.
my use of the word defend, rush to defend, was quite restrained in the context of what came before. Again, I reiterate, I appreciate the nature of the committee. I've been observing these fora for over a decade. And I believe it's quite in order for when an opinion is submitted by an officer of the Attorney General's chamber, that we take the time to distill the various points. I see nothing wrong with what had proceeded before.
I would only add, though, Madam Chairman, and you know that I have used the term cross-examination in relation to how you have conducted these meetings from
interrogation.
Day one.
I commend the word interrogation as a substitute.
I am very deliberate.
I know you are.
Yes, and I just find that, so for example, we invite people to come and to give us their views. And sometimes they are not allowed to finish their sentences before my astute chairman steps in to do the cross-examination. And I think the reason why I believe that it's kind of invidious for yourself and Mr. Foreman to be seen to be at odds now is precisely because Mr. Foreman is supposed to be guiding you and not the other way around.
I think it's the frame, Member Paulwell. I do not come from the school of thought, which I know you come from, to say that one does not interrogate, one part of government does not interrogate the other part of government. I've been in the parliament and I will hear a question raised by one part of government of another. And the immediate comment is, so you all don't talk to each other. Because different parts of government have different functions. And it is correct that the chambers is a principal, the Attorney General is a principal legal advisor to the government. I believe that it is always important to interrogate issues. No, I do not view my interrogating an opinion as tantamount to cross-examination in the sense of how you use the word. I find from where I'm coming from it to be quite healthy to get to the bottom of views and perspectives, because like you, I also want to ensure that the matter is on sound footing. And it is important for me to be clear that one is not equating a preference for another approach to something being constitutionally unsound. So if I appear to be cross-examining, I commend interrogating, because it's also important to understand that opinions are not rendered in a vacuum. Depending on the facts, different principles of law arise. Opinions are never rendered in a vacuum. And the point I'm really making is that if the policy is one of differentiated treatment, in that you are allowing a consideration to be made out of court for certain matters, then naturally you would have to provide the time for that consideration to be made. It makes no sense you're saying that you have an opportunity for the issue of bail to be determined out of court and you do not allow for that determination to take place to ensure that defendants who can properly be granted bail out of court are properly granted bail out of court, and those whose consideration grant of bail is more appropriately determined by the court, then it moves as a second tier. And so if it appears that I'm digging in, it is because it's important that that point be understood. So when I began by asking Mr. Foreman different things, it's really it's really just part of the process, because if one agrees that the Constitution speaks to stages of the proceedings, that a competent legal authority under the Constitution is not limited to a judicial officer, and that even the provision which speaks to trial within a reasonable time mentions a court separately from an officer authorized by law, then a treatment of a defendant by an officer authorized by law, a competent legal authority, doesn't mean that the defendant at a particular stage is experiencing prejudice. Because it's not whether you can detain, it's for how long do you detain. And I think these are important points for us to understand. It's really important for us to understand. Sometimes we forget that this provision, this regime, is geared at addressing a real problem in this society, a real problem. That in Jamaica, the police will get credible information leading to the arrest of a suspect, but that it may take time to convert that information into the form that is required to be presented in court. And if we agree that those who commit offenses are to be brought to book, and we understand the context in which crime is taking place in Jamaica and in which investigations are being carried out, and we are not just paying lip service to an understanding of it, then we really want to ensure that we make available the tools to the security forces and to our wider criminal justice system that would enable us to achieve our goals. So the innocent are to be acquitted and the guilty are to be convicted. And even the guilty, if you can't prove the guilt beyond reasonable doubt, they may end up being acquitted. So when we look at the regime, I get the views that have been expressed by the opposition on the matter. I understand. It's Senator Bunting has said it, that he doesn't support it. I understand. Senator Motley says that she doesn't support it, but it doesn't mean she may not. I think the minutes, I mean, she has said two different things. So if I come across as being sensitive to allegations of unconstitutionality, I am sensitive to allegations of unconstitutionality. And my sensitivity is not a negative thing at all. If I come across as being a little impatient when an allegation of unconstitutionality is made without more then I am indeed impatient to that approach. But I would ask that you do not view my interrogating a matter as an attack, because the purpose of the interrogation is to elucidate. I know some of you may prefer a different style in chairing a committee, because I've heard that this committee has departed from the normal way in which joint select committees have operated. And those who have commented haven't commented negatively, because people do watch to learn. So I'm not being defensive, though I am under duty to defend a policy from my ministry, in the same way that I'm under duty to be appropriately guided. In the same way that it is my duty to hear Chair, different perspectives.
No, yeah. But it's just that, Madam Chair, I believe the appropriate way, insofar as the government of Jamaica is concerned, and that government comprises the minister, the AG's department, is that these issues be settled. Now that they have been raised in this public forum, I think it is important that you tread lightly, especially this public exposure of this difference. And I would certainly love to hear, after this interrogation has, and I suspect we are at an end
Thank you
now,
for substituting the word interrogation.
Yes. What is Mr. Foreman's final position on this matter?
Right. Member Charles, you wanted to weigh in?
Well, good morning, members. I was enjoying the breaking down and the questions and Mr. Foreman's response. I was looking forward to getting to the area where he was going to explain why he thought that one was going to be treated with lesser. So I was actually enjoying that breaking down, and I'd love for Mr. Foreman to finalize that, because I hear him on the committee, and I want to know for sure where I stand. And it's valid. I've read it and it's valid, and I need him to explain that part right here for 6. So continue, please.
Chairman, are you taking all questions for Mr. Foreman, or you would...
No, man, pose yours, Mr. Member Bunting. Go ahead and pose your question.
Well, first of all, let me thank Mr. Foreman for the opinion which I have just read. I wasn't here at the last sitting of the JSC, so I'm particularly grateful for the letter which sets out the arguments. But my interest is in section or bullet point 6.3 of his of the letter dated, I think it's June 12th, where he focuses on the equality concerns. The Constitution guarantees a bundle of equality rights, including in particular the right to equality before the law. And even though I am, what did the term you use? I have no experience at the criminal bar, and I wouldn't want to appear in a criminal trial, as I would likely be the defendant. But it seems just to an ordinary citizen that circumstances a circumstance where someone who there is sufficient evidence to prefer a charge against them is in a preferential position to someone who there is insufficient evidence to prefer a charge. It seems that that person cannot be put in a position which is disadvantageous or worse off than the person for whom there is sufficient evidence to charge them. That is for me, the key point, or a key point in his opinion. And I would, on the face of it, I think we should weigh that heavily. And I would like to hear him expand on that particular point. Sure.
May I ask, before Mr. Foreman weighs in, during your experience as Minister of National Security, did you have any concern about suspects whom you would have been advised are at large and against whom the police are trying to build a case? Say they may have gotten information that it would require some time for them to get info through telecoms, for example. Have you encountered any of those during your tenure as Minister of National Security?
I encountered that during my tenure and even before and after.
Right.
But I don't think that the law should avoid requiring the police from doing rigorous investigation and preparing proper and sound cases to charge someone.
So,
and let me just say,
you said the law should not avoid it?
No, the law should not take away that obligation from the police.
Is there anything in this bill that you see that amounts to the law taking away that obligation?
Well, the whole principle of things like a state of emergency.
No, I'm talking about the bill before that we are deliberating on member Bunting. I'm talking about this particular bill.
Element of the bill.
Which part?
Bill where
Which part of it?
Where somebody can be detained pre-charge for extended periods of time without court supervision.
Senator Bunting, you've read the provision though respectfully. Because I keep hearing, and I want Mr. Foreman, I keep hearing the notion being expressed about what the pre-charge bail regime is. Let me just spend a moment to tell you, or just to remind, what the pre-charge bail regime is, and for the benefit of those listening. The pre-charge bail regime is geared at dealing with a certain reality in Jamaica. The reality is that in a high crime country, where organized crime is rampant, where the statistics show and the lived experience of people that we live in an abnormally high crime context, that it is not always easy for police to get the evidence that is required to charge the criminals. And that we have a culture that promotes informing as a death sentence. So we hear about informer for dead. We have a culture where witnesses are threatened, and there are many cases where the threats are carried out and people are killed, their relatives are killed, their homes are burnt out. That's a reality in this country. I don't know that I'm the only one that know it. The news report it all the time. We hear the allegations, we see the victims. Those of us who represent people in our constituency meet them. People are afraid of the criminals, the hardcore criminals. We don't make gun in this country, and we have high level of gun crime. And so if we believe that those who are guilty must be brought to books, then it would be an injustice for them to benefit from a context where they can threaten people, witnesses run away, witnesses are afraid, and they continue to do their wrongs with impunity. Police say that sometimes the witnesses require time to be spoken to be for their fears to be allayed, for little cooling off, and require some assistance to get them to cooperate. That's not a reality that you are familiar with.
Without charge.
I'm sorry?
Those arguments have led to persons being detained for over a year without charge.
All right. So hold on. Member Bunting, I know you have issues with other. Just a minute. I'm saying I don't think you need to repeat the issues that you have with other pieces of legislation and other approach. We're talking about the bail bill now. And if your concern is about long detention, then the pre-charge bail regime would assist, because someone who is detained on reasonable suspicion of having committed an offense but who is not charged under this regime would be assessed, firstly, out of court by trained officers, and then if that assessment yields a certain result, they are brought before the court for another assessment to be done and for a determination to be made on their liberty. And if ultimately the preferred position is that the court is better placed, then all of these matters will go before the court, and they are not going before the court after an inordinate length delay period.
Madam Chairman, I'm participating as a member, not as a witness or person providing information.
No, but
so let me say, my interest is not the same as the interest of the executive. The Attorney General is the legal advisor to the government. And government here I'm using broadly to include Parliament.
Not the administration, not government of Jamaica, yes.
Not the executive administration. So I believe that he's here not, and I may depart a little bit from Member Paul over there, that he's not just, or the representative of the AG's office is not just advising the executive. In this capacity here today at the Joint Select Committee, they're advising the government more broadly to include Parliament. Now, my interest is making good legislation. And obviously...
And you think that interest is unique to you, Member Bunting? You think it's not shared by me and the other members of the committee?
I'm saying, when I was a minister and I brought a piece of legislation to Parliament and it was referred to a Joint Select Committee, then I came with a different perspective. It was obviously a piece of legislation that I was coming to defend. If I'm sitting as a member of, or a proposed piece of legislation, a bill that I was coming to defend, but if I am a member of a Joint Select Committee, especially one coming from the Senate, I am impartial in how I receive it. I'm obviously bringing my own experience and my own
But you know I don't sit in an impartial place as a minister piloting the bill, and no minister piloting a bill sits in an impartial place.
That's correct.
It doesn't make it a bad thing. You have a special responsibility.
But you are the presiding officer for the committee as chairman, and therefore it is not to use wearing your cap as minister to
No, man.
constantly
No.
be defending the
No.
thing. You need to allow some amount of discussion of
Senator
differing views,
Bunting, you come in and out of the meetings. Remember, you don't normally stay the full length of the meetings, you know. So you can't really fairly say that the deliberations have not been robust at all. Just look at the minutes.
Adam in them attacks, and I'm forced to respond that
Look at the
maybe
minutes.
if I was paid handsomely as a full-time minister, I could do nothing else but attend Parliament all day.
No, I'm
But since
saying though
on
that
salary,
your point
I
is not
cannot
borne out
always
by the
attend
minutes.
all-day meetings of joint select
I am
committees.
saying to you that your
You know,
point
especially
is not
like this
borne
one.
out by the minutes, because the minutes show the robust exchanges that take place, and the points are attributed to the members who make them. So that because you are not
Were not
always
there
present
certain
for
list
your
of
good
members
reason,
like myself and
your
Scott
view does
Motley,
not
sure.
accurately
We
reflect
would
what
not
takes
be able to
place.
get a word in edgewise.
Anyway, you had asked Mr. Foreman a question. Let's get to that.
Yes, sorry. I think the question was about my comments on the equality aspects or the potential equality implications of the two positions. I don't know if I'm being heard clearly.
Yes, that's correct. That was what I wanted you to expand on, because I was very interested in that.
Right. The basic point is that the right to equality before the law requires that persons who are in comparable, analogous, or broadly similar circumstances to be treated in the same way, unless there is a proper basis for treating them differently. And in the context of the constitutional provision, which grounds arrest and detention on the basis of reasonable suspicion of having committed an offense, and the bill's treatment of those persons in a different way in respect of the time period within which they must be brought before a judicial officer. I think there's an argument there that arises from an equality of law perspective. And as I indicated in the letter, a desire to have the person who must be brought within 48 hours before the court being imposed for the purpose of facilitating the trial within a reasonable time is a factor that would be considered in respect of that specific right. But in my view, it does not, it's not clear to me that it's a sufficient response to the separate right, which is the right to all persons who are arrested or detained on reasonable suspicion of having committed an offense to a prompt appearance before a judicial officer. So that if the law says for one class of person, that prompt appearance is 48 hours, it should not have another class of person not having that entitlement, or at least not having it in the sense of that time period being longer than that 48 hours without a good basis. And the only basis that I've heard provided thus far relates to trial and not so much to the need to have under 14.3 the person being brought promptly before the court if they are not if they're not released at the initial stage of consideration of their detention.
What, in your opinion, would be a possible justification by the state for this difference in treatment that could stand up to constitutional challenge?
That's a policy position, and the argument that has been, or the position that has been advanced, is that the person who has been charged with the Part 2 schedule offense should be brought before the court as soon as possible, so that the trial proceedings can be initiated.
Right, but that is repeating the minister's justification. I'm saying we're in a pre-trial stage now, and we're dealing specifically with the right to equality before the law. And by your argument, these two persons, the pre-charge defendant and the similar defendant who has been charged, are in a comparable, analogous, or broadly similar circumstances, because they're both reasonably suspected of having committed the same types of offenses. So in those circumstances, I'm asking you not to, and you know, maybe
my response is that it's not a question that I can answer.
Might be a euphemism to saying you don't have an answer to that. All right, and I accept that.
Yeah, the answer is not within me.
Thank you.
Any other question? So, Member Bunting, it's not that Mr. Foreman is repeating my explanation. I mean, it is a fact that the two defendants are at different stages of the proceeding. And if that fact is acknowledged, then it provides a basis for a differentiated treatment. Because you don't move from detention and charge to trial within a reasonable time just like that. There are numerous other steps that have to be taken in order for you to get to trial within a reasonable time. Right? So that what I have found, Member Bunting, is that you have been using your concerns about other areas of policy and action by the administration. You constantly go to the SOE to inform your position instead of actually looking at the bill and what the regime is providing for. That is what seems clear to me.
No, I agree. I'm constantly guided by a concern not to constrain or restrict or abrogate the rights that is, you know, that's provided for in the Constitution. So yes, that is a constant concern I have, regardless of whether it is the Bail Act, any other piece of legislation, or the serial and routine use of states of emergency.
Yes. No. I mean, it's clear to me that your concern is not, you bring everything else. But my last point is that when you hold true to the Constitution, then you have to hold true to all of it. And the Constitution does not guarantee any of the rights absolutely. It sets a standard of derogation. It specifies exceptions to the rights guarantee, and so that when it speaks to when the rights may be interfered with, then you have to look at whether the standard is met. So it's important to appreciate that. None of the rights guaranteed is guaranteed absolutely. And if a standard is set and the standard is met based on the guidance provided by the court, it doesn't make it unconstitutional at the end of the day. So for me, it's really, it's not whether I would prefer something else, because I understand that if the decision were to be made by you or others, then the decisions probably would be different. What concerns me is conflating a preference with an allegation of unconstitutionality. That really is where I find myself compelled to interrogate. So I may have a preference, but having that preference doesn't mean the other approach is wrong. It's just that I would have done it differently were I the decision maker. But if we get back to the real issues that we're trying to address with the pre-charge bail regime, those that you yourself have spoken about, your concern about lengthy detention, and anyone all of us should be concerned about lengthy detentions. But there is another side that, rights and responsibilities have to be balanced. And rights are not guaranteed to the extent that they allow for people to get away with their wrongdoing. Plain and simple, I think that is the difference in approach. So I am entirely for due process. Due process doesn't mean that someone who is alleged to have committed an offense is innocent. It just means that you can't formally find that person guilty without going through a process which meets a certain standard. I raised the example of the murder convict when he slaughtered the 5 children and her mother in Clarendon. And I said before he pleaded guilty that the presumption of innocence, that due process, the presumption of innocence related to due process, it didn't mean that a person suspected of committing the offense was not guilty. As in that case, long before he admitted his guilt and everybody was talking about him, I said, what it means is that you can't find him guilty until you go through a process. So sometimes we conflate issues, and the only people that benefit are those who realize how we quarrel and give them space to commit their wrongs. No, I'm not saying, I am uncompromising in ensuring that due process is adhered to. And our laws must be fair. But I know that there are those who would want to commit to their wrongs and get away with it. And they sit and watch and they laugh. All right, if there is there any other question? So Mr. Foreman has expressed his opinion and what he finds to be undesirable. He speaks to judicial supervision as an ideal scenario. I take note and I thank him for the views he has expressed. I will just wrap this to say that the rationale for the differentiated treatment, time provision, is to allow for a consideration of bail to be made out of court for one category, as opposed to the other category where the consideration of bail is only to be made by the court. All right, if there is no other question or comment, then we move on to the new business. I believe we had completed the review Madam CPC, was there a further revision of, I know a provision is to be added to the bill which would address those defendants who are taken into custody for offenses other than the scheduled offenses and who are not intended to be brought under the pre-charge bail regime, that if they are not charged within the time specified, then they would have to be released. Has that provision been drafted?
Yes, I had inserted a new subsection 4 in the new
At
clause 5.
clause 5, sub 4?
Yes. Which would read that where a defendant is arrested.
Oh, that's a
or
new
released-
4. Yes.
Yes, this is the new subsection 4 to the reorganized clause 5. Where a defendant is arrested or detained on reasonable grounds that
Can
the
you,
defendant...
the volume is really low.
Where a defendant is arrested or detained on reasonable grounds that the defendant has committed an offense, and A, the offense is not an offense listed in part 1 of the first schedule, and part 1 I'm referring to is what is now numbered as part 2. And B, the defendant has not been charged with the offense within 24 hours after the arrest or detention, the defendant shall be released unconditionally. So that's for the consideration of the committee, and in particular whether that time frame of 24 hours.
Is the timeline 24 hours or 48 hours? Because part of the revision is moving the 24 to 48 hours.
I'm asking
24
it's
hours
for
is under the
consideration.
existing law, and the revised provision is the 48 hours.
Well, this is put for consideration. Normally, when I'm drafting something for consideration, I would start with the status quo. So
Right,
if it
okay.
is
That's
adjusted
fine.
up.
Right, and you reference part 1.
Yes, the schedule has to be renumbered based on the revision we made last time. So
The
what
minutes-
now appears as part 2 will be renumbered as part 1.
Oh, I
and
see.
Part 1 numbered as
Oh,
part 2.
right, so it's from that
Right.
angle. All right, so that provision would make it clear that not every suspect defendant, is to be brought under the pre-charge bail regime. And for those who would come in with the offenses other than the scheduled offenses, they are to be charged within the time frame, and if not, they would have to be released. Because we're really targeting those who, a particular category of criminals for the pre-charge bail regime, and those who would be on the radar of the police high command.
Madam Chairman, as we've progressed through the various meetings, we've made a number of adjustments to the bill, and we keep making amendments, which I am not objecting to, because they might very well be improving the bill. But I must confess a personal challenge in version management, and always ensuring that I have the most current version of the bill working from and commenting on. Could the CPC circulate, maybe after the meeting today, whatever the current version is, and maybe just date it, so that sometimes I pick up 2 versions and I'm trying to recall which is the
Fortunately,
current.
in this case, Member Bunting, you don't have that trouble, because we have the bill and we have a revision. So it's only the bill that came for review and then a revision. Right.
Subsequent to
the list of amendments will be circulated. They usually are circulated for consideration. But this case is not that we're working with various versions of the bill at all. Okay, so we went through...
The second, a revised version came out.
Yes,
and
that's
then
it.
The amendments that we're speaking to now...
Right.
The amendments
but they will be listed. Yes, yes. They're normally all proposed amendments are usually listed and circulated.
Right, but they're not listed and circulated after each meeting, or after each adjustment, I should say. Whenever we have a new addition, it would be helpful.
The minutes reflect them, Senator Bunting. The minutes reflected. So just.
But I'm just asking you to make our work a little easier. So rather than we have to transfer all the
no, man. If you
minutes
look at it, it's not just our work that we make a little easier. No, we make everyone's work easier. So the reason why the minutes faithfully reflect what is agreed is also to make the work of everyone easier. And at the end, the list of revisions is provided, and we're almost there. I think we are on the very last of it, so it will come. But this is not a case where we've had many versions of anything. We had the bill and we had the revision, which was circulated. Unfortunately, the approach taken here is to have practically everything reduced in writing. Last week, when I asked Member Scott Motley to reduce hers in writing, her response was that thankfully the minutes would reflect it, and she would ask that written reflection be taken as a written record of her submission on the matter.
That is indeed true, Chair, and maybe this is a convenient time for me to remind you that I had indicated that I would have to leave.
You did.
Early this morning.
Yes.
Yes, thank you, Chair.
And thank you for your faithful attendance, Senator Scott Motley.
I do, Chair, insofar as possible for somebody who has a job, works, and has not got an increase. Yes, ma'am. I take it seriously.
You know, between you and Member Bunting comes here when he does come here to point out that he's not in full-time employ. I think we probably need to move the membership of the Parliament into full-time. So when you serve either as an elected member of the House or an appointed member of the Senate, that you serve full-time, then it would mean...
And I would really enjoy that, Madam Chair, because I do believe that it is an important contribution.
I know you would, but others will say they are not paid enough to serve full-time. So let us hope that we get to the place where they will be paid enough to serve full-time.
Could I just inquire, Madam Chairman, what time do we cut off today? Just checking.
Not too long from now,
because,
Member
yes, so I do have another committee meeting.
So
I do have another committee meeting at
apart
midday.
from what the CPC has just read for the new 4, I believe that what we will know, we would have completed all of the provisions of the bill, the review of it, and the re-review of it. So we will move to get the list of amendments and the preparation of the report for consideration. Our next meeting is set for Thursday. I will confirm with the clerk whether the time will be enough. I know the CPC has done her drafting already for us to get to the wrapping up of it. We may have an adjustment to Thursday sitting instead of a full meeting to perhaps the first half of the day. And then
Madam
after
Chair.
that, yes, Madam CPC?
I noticed you have been referring to a list of amendments, but what we had actually done is an entirely revised bill based on the reorganization. So that is what would be presented,
all right.
Not a list of amendments.
Yes.
Wonderful.
Right. So So we have that. So it's just to give the clerk now the time to compile the draft report for consideration. All right?
And will that draft report be considered on Thursday?
Just a minute. All right, so Thursday's meeting, we will just do the check to ensure that all of the matters for consideration are considered. And then after that, it will be, the schedule will allow for the preparation of the report. So Thursday's meeting will be to consider the other matters. Anything else for consideration?
And a subsequent meeting.
And then the subsequent meeting would be for the report.
And for us to be able to review
Yes.
it ahead of meeting to consider it.
Yes. All right. So I think we are ahead of schedule for today. We can take the adjournment if there is no other business. So for Thursday's meeting, I will ask the clerk to circulate again the issues that we would be considering. That's right. And we will determine on Thursday or next meeting date for consideration of the draft report. All right, so date and time of next meeting is on Thursday, the 15th at 10 a.m. Will someone move for the adjournment of the meeting?
We'll move, Madam Chairman.
Second.
Who is that now?
Bunting moved.
Buntin and Charles. Very well.
Would always recognize my voice.
Well, you know, Member Buntin, this perhaps is the only meeting that you have spent the full duration of the meeting with us.
That's unkind of you. That's unkind of you. And
All right.
I'm not sure.
Good morning, everyone. The next meeting will be on Thursday at 10 a.m. Meeting is adjourned.
This week on PBCJ Presents.
A lot of the children don't have both parents, you know, in the household. So idle time, with idle hands, and then they can go, you know, so we try and target those areas first. And if you don't have a governing body at home where it is that, you know, you can come and have like a structure, then we try and create it in those communities. So this is what, for instance, the Gloves Over Guns initiative does. But once we show the platform and once we find that neighbors, guardians, parents see their children coming into these spaces, then they support. And that's where the community cohesion comes on board. And then it is, you know, you becoming neighbors, people. What's coming is we want to have shows here where our boxers do not need to travel overseas to build a career anymore. They can do it from here.
Yes.
And the Jamaican public can journey with them from their first fight to the World Championship fight. So